Hello everyone, and thanks so much for dialing in to today's webinar where the Taylor Wessing team will be looking at the IR35 regime, changes to that regime and what businesses need to know about it. I don't think it's too late to start your happy and successful 2021. I hope it's a really good year for you and that you and your families are staying well at this really challenging time. By way of introduction, I'm Helen Farr. I'm one of the partners here at Taylor Wessing in our employment team, and I'm delighted to be joined this afternoon by Liz Wilson, who is another partner but a tax specialist, and of course, last but by no means least, by Joe Aston, who is a senior associate in our employment team. And Joe, like Liz and I, has done lots of work with businesses advising on this change and what it means for businesses. For those of you who are listening, we will be keeping to the hour and there will be facilities to ask questions. So what are we going to cover today? Well, this webinar is going to cover what IR35 is, and I think that's really important because you need to understand the basics to be able to appreciate what's going to change. We're then going to move to have a look at what the government's proposing is implemented from the 6th of April this year, before we move on to the more meaty questions, which is, as a result of those changes, how should you as a business operate IR35? And last but by no means least, we're going to conclude with a series of questions and answers that we've based on the advice that we've been giving to clients over recent weeks and months. What we've done is we've picked a number of the common questions that we've been asking, and we've been asked to deal with, and we'll be answering those as a team for your information and use. So I'm going to hand over to Joe, who's going to talk about what the current IR35 regime entails. Thanks, Joe.
Thanks a lot, Helen. Yes, it seems like a good place to start. What exactly is IR35? And one of the big misconceptions I find speaking to clients on a regular basis about IR35 is that some people think that IR35 is new, so they think that it is coming into force with effect from April 2021. That's not the case. IR35 is a tax rule that's been in force since April 2000. It's colloquially known as IR35. The reason for that is that it was first announced in the 35th press release of the Inland Revenue, obviously the precursor to HMRC. You may also see it referred to the off-payroll working rules, so those terms are used fairly interchangeably. And it's a rule in tax law that applies only to situations where a contractor is supplying services via its own limited company. And what that rule is that the company, as things stand, must treat any fees that they receive through that limited company as if it was employment income, so putting it through PAYE, pay as you earn, but for that limited company, there would be an employment relationship between the individual person providing the services and the end user. So it's a way of ensuring that HMRC is receiving as much tax and national insurance and minimizing the tax that is avoided through the use of limited companies. And that involves an assessment of whether or not, but for the company, the individual would be seen as an employee for tax purposes from an employment status point of view. Now, as things stand, prior to 6th of April this year, it is the in the private sector, at least, it's the contracting company itself which is responsible for determining whether or not a particular provision of service falls within or outside of IR35, and therefore whether or not the limited company must operate PAYE in respect of those services. And because of that, anyone who's listening who's an end user may not have had a huge amount of involvement with IR35 to date, because up until that cut-off point of 6th of April, the end user is largely protected and doesn't have to involve itself in that analysis, and essentially just pays the money gross to the limited company, and allows the limited company to carry out its responsibilities in terms of IR35. And then, so I mentioned before that there's an analysis that needs to take place. So IR35, an arrangement will fall within IR35 if, but for the company, the relationship between the individual providing the services and the end user would be deemed one of employment rather than self-employment. And it's important to bear in mind the distinction here between the assessment of employment status for tax purposes and for employment law purposes. So from a tax perspective, there are only two distinctions when it comes to status from employment law, from a tax perspective. You're either self-employed or you are an employee, and obviously where you fall within that within those two categories will determine how you should be paid and what tax should be deducted. It's a bit different under employment law because there are three different distinctions. You are either employed, self-employed, or you can also be a worker, which is a middle ground which falls in between the status of employment and self-employment. And there are different employment rights which are attracted by each of those statuses. So for the purposes of what we're talking about today in IR35, we are only talking about an analysis of employment status from a tax perspective. So whether that arrangement will be deemed employment or self-employment from a tax perspective. However, we will speak a bit later on about the knock-on effect that that analysis has from an employment law perspective, and some of the considerations that you should be being aware of about how those two different analyses interplay.
Thanks, Joe. And I'm just going to quickly look at next how IR35 is changing. And I think it's always important whenever you're looking at how something's changing to understand the reason for the change. And as Joe's explained, this regime only applies to those arrangements that you may have as a business with contractors or consultants where they're engaging them via an intermediary company. And the real reason for the change is that, as Joe has explained, under the current regime, that obligation to account for tax and to make appropriate deduction falls on the small intermediary company, and they are often small. There's a perception that the rules are difficult to understand, to enforce, and they've been widely criticised. And of course, the government, as we all know at the moment, is very anxious to look at ways in which it can improve its ability to generate revenue into the public purse. And so because of that perception of large-scale non-compliance by the intermediary companies that are expected to manage these arrangements, the government has been very keen to implement changes. And certainly on current statistics, or the statistics that the government used to justify the changes, its estimate is that over 90% of contractors who should in fact be operating and paying payroll deductions simply aren't meeting those obligations at all. So what did the government do? Well, in April 2017, it implemented changes to the way that the public sector should introduce and manage these arrangements. And as a result of those changes, the government estimates that it's been hugely successful in improving compliance and tax revenues in that sector. And as a result of that, the government took a policy decision to introduce the same set of changes, so the introduction of the off-payroll working rules to the private sector as well. Now, originally, these changes were planned to be implemented last April, but they were delayed until this April, so the 6th of April 2021, as a result of the impact of the COVID pandemic. So exactly what is changing? So what's happening is that the expectation is that from the 6th of April, responsibility for assessing IR35 and operating PAYE will shift to the end user client. So the major shift is that emphasis from the intermediary company who has that obligation to make that assessment to your business or the end user business that's actually using and taking the benefit of the services. And we'll come on to look at why it's that entity that has to make that decision in a few minutes. But it's for the fee payer. So if there is someone else in the chain, perhaps an agency who's actually making payments to the intermediary company, it's the fee payer who is obligated to actually make the statutory deductions, so to pay tax, employer NICs, and obviously include the payment of employer NICs too. And in terms of the liability sharing, the way that the liabilities are apportioned is that the liability for not making correct deductions and not paying employer NICs falls on the fee payer, but the liability for determining status falls onto the end user client. And I'm now going to hand over to Liz, who's going to talk in a little bit more detail about how that chain of liability and the obligations are assessed. Thanks, Liz.
Thanks, Helen. So just taking a little bit of a step back then, what we are talking about is the end user, so the business that's buying the services of the contractor, having to work out whether or not it thinks that these rules apply. And if these rules apply, then from the 6th of April, that business will have to put the payments that it would make to the company through which its contractor provides its services. Those payments have to go through the business's payroll, as if those people were actually employees of the business, rather than simply paying gross to the limited company of the self-employed contractor and allowing the self-employed contractor's company to operate payroll. Now, in the very simple scenario, then, this is the end user, the business that's buying the services, having to work out whether or not it has to operate payroll or not, and if it does have to operate payroll, operating payroll and paying the net amount only across to the either the self-employed contractor directly or to its limited company if it's still got the contractual relationship with a limited company. One of the questions that we get asked is from the perspective of the individual contractor, what that really means. And what that really means for the individual contractor is they are getting an amount net of employment taxes received by them. And we'll talk in a little bit about what that means in terms of the negotiation between an end user trying to buy the services of contractors in this way. It also has an impact on the contractors' company's VAT position and their corporation tax position. We'll talk about those a bit later on. So when we're looking at that chain of obligation and liability, the changes that are coming in from April, what it's requiring, what the new rules are requiring, is for the end user, what is called in this picture the client, the business that's buying these services in, to have to work out whether it thinks that the arrangement does fall within IR35 or not. So it has to consider the basis on which the worker will be providing his or her services, the method of it, the factors, the various factors that are in play when looking at the relationship. And then that client has to then work out whether the status of the arrangement is within or outside the off-payroll working rules. And it has to provide that status determination, which doesn't have to follow any particular format, but has to be a written determination provided by the client and the reasons for making that decision. And it has to pass that decision to the worker directly, to the individual concerned. But also, if there are, and there aren't in every arrangement, of course, but if there are other entities in the way, it has to pass them down the chain. So it has to pass it to, if, for example, it's used an agency to procure the delivery of the service, it has to pass the determination to the agency, and that agency would then pass it on to any other agencies in the chain and down to what's called in that picture the PSC, the personal service company of the individual contractor, and then the person themselves. And that status determination, there are obligations in the legislation requiring people to pass it on, and there are liabilities that will fall on entities in that chain if they fail to pass it on. Now, when the worker, thank you, Helen, when the worker receives that determination, the worker has then a period of time in which to respond and dispute it. And they have 45 days in which to respond and give a statement either that they want a reconsideration to be made and the basis for the reconsideration. Of course, if they're happy with the arrangements, they can just proceed. So just moving on then to the new dispute resolution requirements, there is an obligation, which is on the next slide, there is an obligation on the, as that status determination is passed down the chain, then there is an obligation, if there is a dispute, to pass the dispute back up the chain, and for the client, the end user, to remake the determination and to give its reasons again for whether it's concluded that that determination is correct or not. In terms of the actual payment of the payroll taxes, if the conclusion is that payroll taxes should be operated and there is a fee-paying entity in the chain, so if there is some sort of agency in the chain that is actually making the payments to the personal service company, then it's that fee payer that has the obligation to operate payroll. But of course, in terms of the amounts paid by the end user client, the fee payer will be looking, one would expect, to recover employers' national insurance contributions and any additional costs incurred as a result of having to bring that worker onto the payroll. So these arrangements only really apply if you have got a consultancy, an agency that's filling vacancies. If really it's a genuine outsourcing project, and we'll talk about this later, so it is genuinely outsourcing, that the client is genuinely looking for a certain project to be fulfilled, there is an outsourcing to a third party, then these rules don't apply. This is very much looking at that situation where, but for the arrangements in the way, the relationship between the end user client and the individual worker would be one of an employment relationship. There are some exemptions, thank you, Helen. There are some exemptions, and the key one here for these purposes is the small business exemption. So the new rules will apply to all medium and large businesses, but they will not therefore apply to small businesses. And a small business, so this is looking at it from the perspective of the user of the services, the client, the end user, the entity that is the business that is buying the services of the contractor. And so if that end user meets the criteria for small business, the rules will not apply to it. So small businesses are those that meet at least two of the following three criteria: 50 or fewer employees, £10.2 million turnover annually, and a 5.1 million, or of course less, on the balance sheet in terms of balance sheet value. And that's quite a helpful test. It is, though, on a group-wide basis. So it doesn't, you can't rely on the small business exemption if, when you look at your group as a whole, you are clearly meeting, you're clearly not able to meet two of those three tests. And it also is helpful for new businesses. New businesses are not obliged to operate this for the first year that they are in existence. And indeed, if you move to being a small business from being a medium or large business, or from a or back the other way, then there can be a 2-year grace period, depending, that can also be of use. And so moving on, we're going to now talk about how to operate IR35.
Thanks, Liz. So as Liz was saying, there's an obligation on the client, the end user, to pass down the chain a determination. So what we refer to as a status determination statement, or certainly that's what HMRC refer to it as. The next question will be, well, how do we carry out this assessment? Now, the starting point is that HMRC expects clients to take reasonable care in determining whether or not a contractor would be an employee but for the limited company, the PSC, which sits in between the individual and the client. And if they fail to do that, all liability under IR35 will stay with the client, the end user client. So how do we go about carrying out these assessments? The duty rests with the end user, but HMRC do have a tool to assist end users in carrying out this analysis. And the first port of call for all end users who are engaging limited companies should be this test, this tool. So it's referred to as the Check Employment Status for Tax tool. The web address is there in the slides. It's a free tool available on the gov.uk website. Additionally, there is no record kept of the information that's put into the tool. So it is possible for end users to have a play around with the tool, go through the questions, see what kind of questions are asked. But what happens with the tool is that it takes you through a fairly significant number of questions about the arrangement that's in place. And those are questions not just about the contract that's in place, but also about the practical reality of how those how those services are being provided. Now, there's not enough time today to go through every single question or every single factor which contributes towards status. But if you remember, we're looking at employment status from a tax point of view. Many of the questions and considerations are similar, where we're looking at either employment status for employment rights, from employment rights perspective, or from a tax point of view. At a very high level, three of the most important, albeit not all of the tests which need to be assessed, will be mutuality of obligation, the extent to which there is supervision, direction, and control over the individual, and the right of substitution. And on the next slide, we go into a little bit more detail about the kind of questions that you should be asking, and that to a certain degree you will be taken through under the CEST tool. So the concept of mutuality of obligation is the concept as to whether or not there is an obligation on the end user to provide the contractor with a minimum amount of work. And on the flip side, if work is offered to that contractor, are they duty bound to accept the work that's offered to them? Now, in a truly self-employed contracting arrangement, you would expect that there would be no minimum obligation to provide work, and that there would be absolute discretion on the contractor's part as to whether or not that work is taken up. And we make reference here to whether there's a notice period. So on the face of it, the notice period may not be obviously an indicator of mutuality. But obviously, if the end user is required to provide a minimum amount of notice before they're able to terminate, then that does contribute towards an element of mutuality, in that they can't terminate at will, and there's an ongoing obligation, at least for that notice period, to potentially offer services. Moving on to supervision, direction, and control. This all comes down to the concept that an employer-employee relationship is one where the employer has control over how the employee does the work, and that can obviously be a benefit to the end user, to the company, because in some circumstances you do want a level of control. But the greater the level of control and direction, the more significant the likelihood is that that arrangement will be deemed employment and therefore fall within IR35 potentially. So you're looking at things like, to what extent does the contractor determine how and when the services are provided? Do they have, carte blanche to do that when they want and in a way that they want? Or Are there set working times? In which case, there's an argument that there is a greater level of supervision, direction, and control. And then the third of the factors we're going to speak about today is this concept of substitution. And this comes up quite a lot in the case law. To what extent can the individual contractor subcontract or provide a substitute to provide those services? Again, it's consistent with a genuine self-employment relationship if that contractor determines exactly how the services are provided. So if they want to, at their absolute discretion, put forward a colleague or someone else externally to carry out the services, then that is consistent with self-employment, because the idea is that they are providing a project or a service, and the end user does not have control over how those services are provided, as long as they are provided perhaps by a certain deadline. So you're looking for a substitution clause in the contract itself, and that right of substitution should be what we call unfettered. So it should not be subject to the end user's discretion or agreement. But more than that, it's not possible just to draft around the fact that there isn't genuinely a right to substitute. So if the reality of the situation is that no substitute is ever provided, or actually would ever be provided, then the risk is that just by including a provision to that effect in the contract, it doesn't necessarily mean that there is an unfettered right to substitute, and there may still be a risk from a status point of view. And then just a few more examples of the kind of questions you need to be asking in terms of these three tests. One that comes up quite a lot is, to what extent is that contractor, is the end user the only client of that contractor? So in genuine self-employment contracting relationships, as a general rule, that contractor will be able to provide services to a number of different clients, and if it's actually the case that they work full-time for one end user, then that will increase the risk of the arrangement falling inside of IR35. From a supervision, direction, control perspective, to what extent are there reporting obligations internally? The more there is a requirement to report internally to the end user, the greater the risk is going to be. So that's just a very high-level run through some of the tests. But the very important thing to be aware of is that they are not the only criteria that need to be considered. And the first place to look is the CEST tool, and to go through the tool and all of the questions on a case-by-case basis. It's very important that you assess each relationship on a case-by-case basis, rather than, for example, grouping a number of people together. The reason it's so important to go through that CEST test using the online tool is that HMRC have confirmed that they will stand by the outcome that you receive from that CEST tool, as long as the information you provided is accurate and the tool has been used in accordance with the guidance that's provided by HMRC. So you are essentially providing yourself with a shield, assuming the outcome of that CEST tool is that the arrangement falls outside of IR35 and you've entered accurate information and followed the guidance. You are then able to use that to defend yourself. For example, should HMRC carry out an audit and ask you to show on what basis you've determined that arrangement falls outside of IR35. And as Liz mentions, the obligation then is to pass the results of that down the line to ensure that the limited company receives a copy of that, so they're aware of how you carried out the analysis and what the result has been.
Thanks, Joe and Liz. So I think we've taken you through sort of what IR35 currently looks like, what's changing, and that framework of the new changes. And we're now going to spend the last part of today's webinar looking at those steps, what action you need to take now as a business to get ready for these changes. And a question that we're being asked very commonly is, what steps should you take as part of your business planning to manage those existing arrangements that you have in place now, but that you know are extending beyond the 6th of April 2021. So Jo, what would be your advice on that, to that question?
So the first answer would be that you need to be starting to prepare as soon as possible if you haven't already. So the risk is that you see a deadline of 6th of April and you think, well, that's a few months away, so we can wait and only start preparing later on, for example, in March. As we'll discuss, there are a number of reasons why you should really be looking to plan in advance as much as possible, because actually there is quite a lot of analysis and work that is required to carry out these status determinations and to pass on the information, as well as the potential obligation or requirement to renegotiate existing contracts. But from a practical point of view, the first thing you should be doing is deciding who within the business is responsible for carrying out this analysis. So there needs to be a determination internally, who is it going to be who is going to take responsibility. So it might be someone in the HR department, it could be someone from the tax team or the operations team. So you need to be deciding who it is, whether it's one person or a team of people who are going to carry out this project, because it is a project that needs to be carried out. Once you've decided who's doing it, you need to basically carry out an audit of the existing contracting relationships that you have, where those contractors provide service via a limited company. So you need to be gathering copies of all relevant contracts, but also reaching out to whoever it is within the business who has and manages those relationships, to find out from a practical perspective how those relationships work on the ground, rather than just what it says in the contracts. Because you need all of that information gathered together so that you can then insert it into the CEST tool on the government website to then elicit a response as to whether or not it's likely to be deemed inside or outside of IR35. So once you've got that information, obviously you then need to go through the CEST tool. Again, like I say, it should be on a case-by-case basis. So you shouldn't be deciding that, well, you have 5 people who provide roughly the same services, so you'll just do one test for all of those 5 people. You should do it on a case-by-case basis, so that you have the paper trail and a copy of the outcome that you can put on the file in each case, and then obviously provide that to the limited company. Once you've run the CEST tool in respect of each arrangement, you will hopefully get one of 2 outcomes, although as we'll mention later, there is a possibility that the outcome will be undetermined. If the decision is that it's outside of IR35, and assuming that is how you are treating them at the moment, so you're not deducting tax as things stand, you will need to obviously keep a copy of the CEST determination. Make sure you brief internally about the outcome and therefore what, if any, changes are needed, and obviously send a copy of that CEST outcome, potentially with a covering letter explaining what it means. That will be your status determination statement that you're sending down to the service company, whether that's via an agency or otherwise. If, on the other hand, the outcome is that they are inside of IR35, then you potentially have a bit more work to do, because you will need to decide what the next steps are. So the first question will be, well, how important are they to the business? So is it simply a situation where, because of this additional administrative and cost risk, you perhaps may no longer want to engage them? If that's the case, are you able to terminate their arrangement without penalty? So you need to be looking at the contract and determining what the termination provisions are. And it's quite important, as I said at the beginning, one of the reasons why it's so important to be preparing now is, for example, if you have an arrangement where you have a 1-month notice period and you potentially need to be terminating prior to 6th of April, then obviously you need to make sure that that notice is being served in good time. If you decide that actually they're important to the company and you want to continue engaging them, if the outcome is that IR35, that the arrangement will fall inside of IR35, then you are obliged to put them on payroll of the company. Now, it's not necessarily as simple as that, because you will have to assess the provisions in the contract to see to what extent you're able to do that, because you will most likely be agreeing to pay the limited company on a gross basis as things stand. So to what extent do you have the contractual ability to change how you are paying someone? And either do you have the ability to unilaterally amend how you pay someone? Do you have an ability, a contractual ability to renegotiate if this kind of thing comes up, for example? And bear in mind that there will be an element of management in terms of that relationship, because they may well disagree with your analysis. And even if they don't disagree with your analysis, they may well say, well, if there is that additional liability, that should not be put onto me. And actually, it should be the end user that's on the hook for that additional liability in terms of tax and national insurance contributions. Now, to a certain degree, it will depend obviously on to what extent you are able to amend the relationship and how the individual is, or how the limited company is paid from a contractual perspective. So it's a balance between a negotiation and a management of that relationship, and also properly assessing what the contract says and what you can and can't do. And finally, where you're in a situation where you're putting someone onto payroll because the relationship is inside of IR35, you need to decide whether you're just going to stop there. So are you just going to put them onto payroll, but continue to engage them via a contract which states from a employment law perspective that they are still a limited company contractor or a consultant? Or in the circumstances, does it make sense to also take them on as an employee from a legal employment rights point of view? Now, there are pros and cons to doing that. The cons from the client's point of view will be additional costs. So that individual will be entitled to paid holidays, national minimum wage, and rights under the working time regulations. But on the flip side, where you are deciding that you're going to pay someone as an employee, benefits of having them as an employee from a contractual and an employment law perspective is that you have more ability generally to control what they can and can't do. So if someone's an employee, you broadly speaking can stop them from working elsewhere contractually, and there's also the potential to have restrictive covenants that stop them, for example, joining a competitor once they leave you. So it's weighing up the pros and cons of bringing them on as an employee from a legal and employment rights perspective, as well as what their expectation will be, which might be, well, you're treating me as an employee for tax perspective, from a tax point of view, I should also have all of those employment rights. So that's another thing to bear in mind.
Thanks, Joe. Now, Joe mentioned that one of the impacts of that assessment is that you may decide to actually move contractors to the payroll. Liz, what's the impact for the business of doing that?
Thanks, Helen. So merely deciding that this arrangement is within IR35 doesn't ignore the fact that there is an entity here, the contractor's personal service company or partnership, which is in fact providing the services. It sort of looks around that and applies payroll to the amounts. What that means is that because, as Joe said at the beginning, this is a tax test and not an employment test as such, then merely requiring, because the rules apply in this way, that the payments have to go through payroll doesn't mean that the worker, the ultimately providing the services, is treated as an employee for employment law purposes. And the Revenue's made it very clear that this is purely a tax test, not a test of employment. Now, when Joe was looking at the factors earlier, as he was sort of teasing out, a lot of these factors are employment as well as tax case factors that treat somebody as employed. They're not determinative, though. Each and every one of them by themselves would not necessarily mean that you were within IR35 or not within IR35. So, for example, you can have no right of substitution, but still fall on the outside of these rules. And so if you are within IR35 and you're put onto the payroll, that effectively means that the company itself, the contractor's company, is receiving less money, provided that's what the contract allows you to do. And so that end user, that contractor may well then say, well, this arrangement isn't worth it anymore. If I'm not getting the benefits from my company, being able to extract money by way of dividend and pay less tax overall, then perhaps it's not worth the arrangement continuing, and I may as well just provide my services directly. In terms of retrospective action, there was a concern that if the conclusion was from the end user that somebody was within IR35, then that arguably means, if it's an ongoing relationship, that the personal service company hasn't operated payroll correctly on everything it's received, and concerns that that would mean that the revenue would open an audit. The revenue have said that they won't take retrospective action. They'll only look at the arrangements that are in place from April 2021, so from April this year. Obviously, that they have to caveat that, and it may be that this change in status, particularly with high value contracts, might encourage the revenue to look into it in more detail.
Thanks, Liz. Another point that we're often asked about is what should you do if you are using an agency in your supply chain? So, Joe, what hints and tips can you give the listeners about that?
Yeah, the simple thing to bear in mind when there's an agency involved is that doesn't avoid the end user being responsible for carrying out that status determination. So, if we think back to the diagram that Liz spoke to earlier, all that happens is that there's an additional party sitting in between the end user and the limited company. That agency will most likely be the fee payer, so they will be responsible for deducting payroll taxes from the pay which they receive from the end user before paying it to the limited company. But the requirement to carry out that determination still sits with the end user. So the important thing to bear in mind is that using an agency doesn't pass on that liability. The other thing just to bear in mind when you are using an agency is that, as with all of these arrangements, you need to be looking very carefully at the contractual provisions and how they apportion liability. You also want to make sure that the agency is contractually required to comply with its own obligations under IR35, including making sure they pass the status determination statement on to the limited company once they receive it from the end user. So, key thing, make sure you are looking at those terms with the agency, and any new arrangements are properly negotiated to fully protect you as the end user.
Thanks, Joe. Now, Liz, we're getting lots of questions coming through the chat about using contractors outside the UK. And there's really two scenarios here. Either your UK-based business using someone based outside the UK, or from time to time, you may be the end user itself, so you may have a subsidiary using contractors outside the UK itself. What would the advice be here?
Thanks, Helen. So I'm conscious of time, so we will go through this quite quickly. But if you are an end user, the test is whether you have a UK connection, and you have to look immediately before the tax year in which you are engaging with the contracting entity. So when you're buying the services, immediately before the beginning of that tax year, and you have to work out whether you yourself are resident in the UK for tax purposes, or you have a UK permanent establishment. So in other words, to put it a different way, if you, the end user, are subject to UK corporation tax, then you have to consider the operation of these rules. Regardless of whether you are an end user resident of the UK or have a permanent establishment, if you use somebody to provide the services who is based outside the UK, then there is not a question about whether you have to put them on payroll from a UK perspective, but you obviously should ensure that you take advice from a tax and employment perspective in that local jurisdiction to the jurisdiction of the provider of services as to what the risks are to your business. these are the sorts of issues that actually we come across all the time, not just when we're advising on these arrangements, but when we're advising on the buying and selling of groups that have arrangements like this within them. So it is quite important to get local advice and to get it right.
Thanks, Liz. And I think we're often being asked about new arrangements that start on or after the 6th of April. And I'm going to build on Joe's very full answer to what you should do with your existing arrangements. I think for those new arrangements, if you're contemplating entering into a new arrangement now that you know is going to be subject to the new regime, absolutely you must make sure that you have in place your core team who can make that assessment. But I think it's more fundamental than that, because you really do need to make sure that you get the message out there about these changes. So make sure that your managers also understand what's coming down the track, and that they don't have the ability to engage contractors unilaterally, because so often what happens is we're approached by HR managers or people in finance with concerns about X manager who's engaged someone without reference to them. And of course, that will undermine all of your fantastic work in preparation for this new change. Absolutely, you do need to think about how you're going to manage the detailed status assessment points. The CES tool absolutely is your first point of call for that, for all of the reasons that have been articulated. But do think about how you're going to cope with those tricky areas where there's either no status determination or it's just not clear. Absolutely, you need to think about processes and procedures for informing the consultant of what you've decided about his or her status. And if you're either in the process where your business tenders for work or you're receiving tenders, look at those carefully, because from now, you need to be pricing for this risk if you're going to be using contractors. And I think that's a really important point. Make sure that all of the tenders are submitted on the right basis. And I think, as Joe and Liz have articulated, this is not a finite assessment. It's not, you have to keep things updated. Absolutely, whenever the scope of work changes, but do keep things under review so that you're clear about exactly what's happening on the ground and that your assessment reflects that. So, Joe, can you quickly give us some tips on what you should include in your new agreements with contractors that are going to come into force from the 6th of April?
Yeah, absolutely. I mean, very quickly, when drafting new contracts, obviously you have to be very aware of the factors which may determine IR35 status. So as a very, very general rule, we always recommend avoiding contracting agreements that are for a period of more than 2 years. And the reason we say that is because, as many people will know, if there is an assessment from an employment status point of view, for employment law purposes, that someone is an employee, then after 2 years they gain unfair dismissal protection. So it's just a sort of trigger period after which a significant right is gained, and therefore there is more risk. So really, for contracting arrangements that fall outside of IR35, generally speaking, you would expect them to be on a project basis, so limited in time and based on the delivery of services, rather than, for example, for a fixed period of 2 years or more. And similarly, avoid using short-term but rolling contracts, because essentially they do the same thing. And if they're not linked to a specific project, for example, then that's going to increase the risk. Very important to bear in mind that you can't just draft around problems, so you need to make sure the contractual terms reflect exactly what is happening on the ground, and assessing the reality of the situation and deciding before you even start drafting a contractor agreement whether that's right, or whether something is genuinely going to be an employment type relationship. And if you do decide that something falls outside of IR35 and you are going to proceed on the basis that it's self-employment on that basis, you need those get out clauses. So if, for example, those things change and you need to move someone within IR35, do you have the contractual ability to do that, or at least a contractual ability to renegotiate and adjust the terms as a result of that? So it's future planning when drafting the contract as well.
Thanks, Joe. And another new development that's been introduced with the new procedure is, as Liz was talking about, the new dispute resolution process. So what would be some key pointers for those listening to avoid disputes in the contracting chain?
Yeah, so it's going to all be about communication. So Liz has mentioned already the sort of requirements around disputes and how you need to respond to them. So it's going to be a combination of making sure terms are drafted appropriately so that those disputes are dealt with properly, but also ensuring that there are procedures in place to make sure you're talking properly with your counterparties throughout the chain. Making sure that, for example, there are mechanisms in place where arrangements are reviewed on a periodic basis, and particularly where circumstances change, for example. The use of agencies is a potential way of reducing risk, but again, it all comes down to how those relationships are contracted into and how those terms are drafted. Another thing that was mentioned briefly earlier was this concept of an outsourcing. So in a situation where there's a genuine outsourcing of a service, and therefore it is not a direct supply of services by the limited company to the end user, then what would otherwise be the end user may be able to minimize risk to it by fully outsourcing that task to a third party, in which case they would avoid the requirement to carry out the IR35 assessment themselves. So just a few examples of things to be aware of when trying to avoid disputes.
Thanks, Joe. And I think another area that people are concerned about is obviously avoiding disputes with the contractors themselves. And there is, as we've said, baked into the process, this sort of dispute resolution process, which expects you to sort of deal with any issues that they may have about their status as an internal grievance. So you need to make sure you have someone internally who's skilled and is comfortable to deal with those sort of issues. And obviously you could decide to avoid the issue altogether by, as Joe said, either using outsourcing or avoid using contractors altogether. And certainly that's a lead, and that's something that many large employers have decided. It's just too difficult, it's too costly, and so we've seen some very well publicised examples of employers like Lloyds Bank, Barclays and others who've publicly said they're not going to be using these type of arrangements going forward because of those reasons. So Liz, just as a final point, we've had a lot of, there's been a lot of sort of challenge and debate in the press about how reliable the CESS tool is. And as a tax practitioner, what are your views on this?
Thanks very much, Helen. So just in the last couple of minutes, we just wanted to touch on this CEST tool, this check employment status for tax tool. As Joe said, it's anonymous. You can go in there and you can apply the facts that you've got to the CEST tool and see what answer it gives you. And it has three possible outcomes. One is that it's outside IR35, so breathe a sigh of relief, no need to worry. One is that you're within IR35, and therefore you have to consider operating payroll on all the amounts. And the third is this grey category, this undetermined category, and that's currently the result in 19% of cases. Now that might be because people are putting through the facts from actual real life cases, real life tax cases that have gone through the tribunal to see whether the CESS tool is providing the right outcome. It may be that the people are deliberately, choosing issues on the grey side to see what CESS will come up with, but we know that many clients are struggling with this. Many clients do have undetermined answers, and the question then is, what do you do next? Because an undetermined answer is one that you can't, of course, use in any practical sense. The Revenue's guidance is that they advise that you then check the employment status manual, and they will be continually, they have promised, updating the CEST tool as cases are won or lost through the tax tribunal and higher, and they will be continually refining their employment status manual too. Now, the challenge with both of those tools is that they are based on the Revenue's view of the cases, and it's not necessarily the same view that we as practitioners and tax advisors would consider to be the outcome of the cases. So where you do have answers that are in that undetermined grey category, then yes, the first step is to look at what the revenues view is from the manuals, but then it may well also be to seek advice on the actual cases themselves, because there is a body of law that stands behind all of this, and it's really that law that tells you what the right answer is, not the revenues tool. All that being said, the revenue have said that they will stand behind it. So if you have applied the CESS tool and you've kept your the answers to the tool and the answers that you gave to the tool in order for it to give you the outcome, then the revenue have said that provided you have been reasonable and honest in your responses to the CESS tool, you can rely on that determination. So Helen, would you like to say a few words by way of roundup?
Yeah, look, I'd like to say firstly, massive thanks to all of you for dialing in. I hope that you've really enjoyed and found today's session useful. We've had lots of questions through on the chat, and we will be answering those personally. So thank you all very much for your questions. If you do have any further issues or questions for any of us or your usual Taylor Wessing advisor, please do get in touch. We'd be absolutely delighted to help. So I think that leaves to me, it falls to me to say thank you all very much for joining us. We look forward to welcoming you to our next Taylor Wessing webinar, or ideally, he's hoping we can all get together in person sometime soon. So thanks very much, and with best wishes for all of us for the rest of your day. Thank you.